What I have for you today is a follow-up of our previous discussion of the Coca Cola case, and this is from November 2023. And as you can see, Coca Cola is a petitioner and then the Commissioner of Internal Revenue, the respondent. And if you look at the cursive text at the bottom, you can see quite a few parties have appeared for both. A 10-second commercial. If you want to learn more about international taxation or transfer pricing, or treat yourself to an all-round update, or if you want your team to learn or stay updated, please visit my online courses. Now, just a brief reminder about the case. We had the Coca Cola company at the top, and it held export, and export had these subsidiaries which were supply points. They made the Coca Cola syrup, and our case is going to deal with the Brazilian subsidiary. The supply point sold the syrup to bottles, to concentrate to bottlers, who then sold it to supermarkets with the help of service companies who took care of basically the global marketing of all of these products. Now, in the original case, the supply points were adjusted for a significant amount in terms of transfer pricing, saying that they earned way too much money. Among them was the Irish supplier, which obviously was quite low taxed. And part of the issue was that Brazil should have paid royalties to the Coca-Cola company for the use of a lot of IP, but Brazilian law limited the amount of royalties that could be paid under Brazilian law. So the Brazilian subsidiary paid dividends instead of royalties, but not up to the amount that the IRS has determined would have been the arm's length price for these licenses. So when the Coca-Cola case was decided, the same issue was already before another chamber of the tax court in the 3M case. Both of these cases have been discussed on this YouTube channel, and I will put the links to both cases below. Just a brief reminder of what was going on here. You had 3M Innovative Properties giving license to 3M Brazil, and 3M Brazil not paying enough royalties to 3M Innovative Properties. And a brief summary of the facts: 3M was a parent company. 3M Brazil used trademarks owned by the 3M company. They paid a royalty of 1%. It should have paid 3%, but it couldn't. 3M Brazil also used patents and non-patented technology. The 3M reported the trademark royalties in its consolidated U.S. income, but the IRS said that they should have been much higher under Section 482, and 3M basically argued, well, we couldn't do that because Brazilian law doesn't allow it, and under transfer pricing rules, including Section 482, if you're not allowed to legally make these payments, you cannot be forced to. However, the IRS argued that the Brazilian legal instructions did not meet the 1994 regulation, which said that you need to fulfill 7 conditions before you can argue that you do not have to make what would have been an arm's length payment. And the 3M company argued that their requirements were invalid because they failed the Chevron Step 2 test or the State Farm test, and that the IRS regulation was invalid because it failed the Chevron Step 1 case. And these issues were also discussed in the video that I referred to. And the court, you can see, it really goes about this first one, right? The restriction must affect uncontrolled payers. And the Brazilian rules said that you could not deduct payments above a certain amount paid to related parties, but not to unrelated parties. And under both 482, Chevron Step 2, and State Farm, all of 3M's arguments failed. So once the tax court decided the 3M case, the other chamber could now pick up the Coca Cola case and apply the same doctrine. So let's see what happened in this case. The court starts by saying the question remaining involves petitioner's Brazilian supply point. It paid no actual royalties to the Coca Cola company between 2007 and 2009. It compensated the Coca Cola company for the use of these intangibles by dividends of 880 million. We held that the arm's length royalty obligation was actually 1.768 billion, and therefore there was still another 882 million missing. The Coca Cola company stipulated Brazilian law placed no limit on the supply point payments of dividends. So in other words, even though the payment of royalty was limited, TCCC could have paid the remaining 800 in dividends, and the court therefore says, well, why did you do that? And in its defense, the petitioner relies chiefly on Procter & Gamble Co. versus the Commissioner from 1995. And what happened here was more or less the same thing, except now it was a Spanish licensee that should have paid to Procter & Gamble, but Spanish law prevented it from making those payments. And Procter & Gamble won the case. But the court goes on to say, given the peculiar fact of this case, it is not clear that Procter & Gamble dictates the answer. The two cases are distinguishable in a relevant factual respect. The Spanish subsidiary in Procter & Gamble did not have the distributable earnings from which to pay the dividends. The Brazilian supply point, by contrast, could legally have paid the petitioner dividends exceeding 1.7 billion, which is what it should have paid, right? So the court says Procter & Gamble doesn't apply here because they were loss-making. Brazil had a lot of profits and it could very easily have paid those dividends. The Coca-Cola company then argues and says that, yeah, but hang on, dividends and royalties are different. You can't expect us to pay dividends when we're supposed to pay royalties. And the court, in very flowery language, attacks this argument, right? It says, it seems to us that the petitioner is attempting to use Brazilian law as both a shield and a sword. For federal income tax purposes, petitioner took the position that Brazilian law permitted it to receive dividends in lieu of royalties as compensation for the Coca-Cola company's intangibles. But it also seeks to use Brazilian law as a sword to prevent the receipt of dividends in lieu of royalties in a larger dollar amount. Okay, so to the amount that we think we should have paid, it is okay to pay dividends, but to a larger amount, dividends are not royalties. And the court says this one-way ratchet is not entirely convincing. And then the court finally concludes on this point. It says, for these reasons, we think that the Commissioner advances a reasonable argument that the Brazilian legal restriction did not actually block the payment of arm's length compensation. So here already, TCC basically lost its case, right? The court says you had enough dividends, you could have paid the full arm's length price as dividends. What I don't know, as not being a US practitioner, is whether these dividends that were received were treated in the US as dividend payments. In other words, whether the TCC received a tax credit for an underlying Brazilian tax, or whether these were simply treated as royalties, in which case, of course, the full amount would be taxed in the US and that there would be no dividend credit for any tax paid in Brazil. And then we come to the next issue, and the main issue in this case, and that is whether the royalty contracts were grandfathered and protected from the adjustment, because the revenue ruling that said that you must fulfill these 7 conditions only came into being during the whole licensing process between Coca-Cola and Brazil. So let's just have a quick look. I mean, the original 8 trademarks were licensed before 1985, 17 November 1985, and they were registered with the Brazilian Patent and Trademark Office, right? Which means they were enforceable in Brazil, and they predate the so-called block rules in the 482 regulations. And these trademarks concern Coca Cola, Coke, Fanta, Sprite, and the Fanta bottle. It's interesting to see the kind of IP that was covered here. Then there were several additional trademarks which were post 1985 and the 482 block regulations, or block payment regulations, I should say. And these concerned, among others, the dynamic Coke ribbon, Coca-Cola Light, Coke Light, Coke Classic, Sprite, Coca-Cola in Spencerian, which I assume is a new font, and then the Sprite bottle also got patented. And then there were 53 core trademarks which were also post 1985, and these concerned issues such as or IP such as Coke Zero, Diet, Fanta, the S logo in Sprite, the CC contour, the Coca-Cola contour bottle, and the polar bear, etc. And then there were non-core trademarks, primarily used in Brazil, if I understand correctly, and these were for brands such as Dasani, Minute Maid, Powerade, Aquarius. Now, having grown up in South Africa myself, I remember at least one or two of these names as a child from that time. And now the question the court needs to answer is, whether any of these trademarks are grandfathered under 482, and if so, then the requirements of 482 do not apply for making in order to make the payments. And if they are, obviously you're going to have to split the adjustment referring to the pre-1985 trademarks and the post-1985 trademarks. But things do not pan out that way for Coca-Cola. The court starts by quoting the 482 regulations and the relevant sentences. It says, for the purpose of this case, we need go no further than the first condition. And remember, this is also what we talked about in the 3M case. A foreign legal restriction, whether temporary or permanent, will be taken into account only if the restriction is publicly promulgated, so it's published, and generally applicable to all similarly situated persons, both controlled and uncontrolled, right? And the Brazilian rules in the 3M case failed because they did not apply to payments to uncontrolled parties. But then the regulations go on and say these regulations will not apply to transfers made or licenses granted to persons before November 17, 1985. Now the question is whether general transfer pricing rules would still ever apply, but in any case these 7 conditions and this very first one would not apply. And then the court goes on to say petitioner, which is the Coca-Cola company, asserts that all of the TCC's economically significant intangibles were licensed to the Brazilian supply point before 17 November 1985. And part of the argument here was that there was language in the trademark agreements which said, we cover the Coke name and the Coca-Cola name and Fanta name, etc., etc., and all other things like these, right? And the taxpayers seem to have relied on this and all other things like these to say, well, then the rest must have been covered as well. But the court shot down that argument, saying, the Brazilian Patent and Trademark Office is very clear that only patents and trademarks transferred or licensed with specificity are protected. And if they are not protected, you are not the owner, so therefore the transfer then must have happened post 1985 in new contracts, right? The court also says, by the way, a lot of the stuff that you license were only developed by the Coca-Cola company and its R&D team after 1985, so there was no way they could have been licensed, right? In advancing this argument, I'm just reading the text further, the Coca-Cola company focused mostly on trademarks, largely ignoring other intangibles that were essential to the supply point's manufacturing operations. And if you remember the first case discussion, it was also that the supply points owned significant marketing intangibles, right? And the court shot that argument down there already, saying you had nothing to do with sales and marketing. You may have made some payments in that regard, but that was simply because the rest of the group needed cash and then they needed to put a name on the invoice. But you were making stuff, you were not selling stuff, right? And that argument continues to be built here, and the court says petitioner focuses on the 15 pre-1986 trademarks, but only 8 of these were licensed under the 1963 agreement recorded by the Brazilian Patent and Trademark Office, and they were the only trademarks enforceable against third parties under Brazilian law. We just talked about this, right? Another 53 trademarks covering the TCC's core brands were licensed to supply points after 85, and the blocked income regulation clearly applies to them. The same is true for more than 100 trademarks covering petitioners' non-core brands. And now we come to this thing of, so if 8 very significant trademarks were covered and the rest were not, how do we split this license liability, right? And the court says the Brazilian supply point manufactured concentrate. Exploitation of the intangible described above was essential to the Brazilian supply point's ability to discharge the manufacturing activities that generated its revenues. In other words, the patents on how to make things, the secret recipe, all of that stuff. But the court says its use of and reliance on the Coca Cola company's trademarks in the manufacturing process was quite limited, i.e. the original 8 trademarks that we're talking about, right? While we do not dispute, and this is the court saying, the tremendous economic value inherent to the TCC's trademarks generally, we find that the TCC's non-trademark IP held the greatest relative value for the supply points, including the Brazilian supply point. After all, the supply points was engaged in manufacturing, because supply points sold concentrate to preordained buyers. Remember, they had to sell it to the bottlers, which were appointed by the Coca-Cola company. It had no occasion to use TCC's trademarks for economically significant marketing purposes, right? And so what the court basically says is, we can attach very little value to these 8 original trademarks in this context where you are a manufacturer, not a distributor, right? And the court then also concludes, it says, because petitioner has failed to establish what portion of the aggregate transfer pricing adjustment might be attributed to the exploitation of the 8 grandfather trademarks, which basically says they couldn't prove what should be allocated to that, we have no alternative but to sustain that adjustment in full. So it was the full 1.7 billion that should have been paid. 800 million has already been paid in dividends, and now the Brazilian supply point should have paid the other 800 million in dividends, as well as it was allowed to do under Brazilian law. The Coca-Cola company itself came with a press release about this case, and it is quite feisty, from 9 November 2023. It says the Coca-Cola company disagrees with the actions of the IRS and the latest decision by the US tax court. While we disagree with the court's interpretation of the facts and the law of the case, we are pleased to move closer to a final resolution of the tax court case so that we can pursue an appeal where we can assert our claims and vigorously defend the company's position. These are quite some fighting words, and I mean, it means that we're not done with this case. Yes, there will be more videos coming. But I also wonder whether this case is whether this statement is partially market driven, because remember, Coca-Cola makes primarily consumer products, right? In some countries, maybe not all, if a company is seen as not being socially responsible, e.g. by not paying its taxes, customers might shun their products and go for the competitors. And of course, that might be the last thing that Coca-Cola want in this case. However, regardless of whether it's market-driven or not, there will, we've been promised, be an appeal and further cases to discuss. But before that, we will look at many other cases, and I look forward to seeing you in next week's video. Bye for now.